Joining me now on the phone is Andrew Weissmann, MSNBC legal analyst and former federal prosecutor. I will let you register whether you agree with our surprise, but also if you could, Andrew, because to me, this decision by the Supreme Court, this very surprising decision, is also an indictment in many ways on the Justice Department, which has so clearly failed to hold Donald Trump accountable, even for an attempted coup. But it is New York. It is the stalwart pursuit of justice by Alvin Bragg and the commitment of this judge to follow through and to have this case come to finality that has brought us here. Your thoughts?
Well, there's no question that you can't say enough good things about Alvin Bragg and about the state court judge here who did the right thing and kept their head down and wanted to make sure that the rule of law applied regardless of station. There's a lot of blame to go around, including to the Supreme Court, in terms of why the federal cases did not proceed in the same way that we are seeing the state court proceeding. A couple thoughts on the 5-4 decision, where the key difference here is that the Chief Justice switched, that said that we had a presidential immunity decision that seemed to suggest that we could see a stay coming in place, but the Amy Coney Barrett had dissented on the key part that's relevant to this, to the issue that was before the court, and Chief Justice Roberts also switched. So that made, those were the two justices who joined the so-called liberal justices to make up 5. And I think, one, the main thrust and the take-home here is that the court said that the rule of law is going to apply the same way to Donald Trump as it does for anyone else. That is a long time coming, Joy. I know I'm preaching to the choir here, but they are basically saying this is the normal course. You raise issues on appeal after sentencing, not before. That's what would happen to you and to me and to everyone else. And that's why you have 5 justices saying that. Now, the bad news is that it was a 5-4 decision. This should have been 9-0. And so what we are going to be seeing in the next 4 years is an issue of whether this will continue being 5-4, and we're going to have this block of the 4 dissenters, and when we're going to see Justice Roberts and or Justice Amy Coney Barrett switch back. And I think that this kind of dynamic is one that I think we better sort of fasten our seatbelts. But tonight, we are seeing the Supreme Court having done the right thing after they took so long to decide the presidential immunity decision, delayed the federal cases inordinately. But here, they are giving the green light for the president-elect of the United States of America to be sentenced tomorrow in state court for 34 felonies that he was convicted of by a jury of his peers.
It is an extraordinary and historic moment. And let me go back to you, Lisa. I believe we still have Lisa. What was the reasoning of the 4 in saying that Donald Trump should not be sentenced? Did they put forward their reasoning?
They didn't. And Joy, this is sort of the peculiar thing about these shadow docket applications like this. When somebody doesn't come to the Supreme Court through an ordinary posture where they're going through all of the conventional appellate steps, but rather they make an emergency application to the court, oftentimes the court, when it grants or denies, they don't explain themselves either. All we got from the majority here is a paragraph. Now, the dissenters here could have spelled out why it was that they were opposed, and they chose not to. And that's going to be how it remains. But I want to focus back on 2 justices in particular, Justice Roberts and Amy Coney Barrett. First of all, as Andrew said, Justice Barrett didn't agree with the majority in that presidential immunity decision on that one facet that affects this case, which is, were you going to grant former presidents immunity from even having evidence of their official acts used in trials having to do with unofficial conduct? There were 5 votes for yes, but Amy Coney Barrett separately wrote and said, that doesn't sit right with me. I'm not here for that. So it doesn't surprise me that she went with the 3 liberals on that particular issue. And as for Justice Roberts, remember, he wrote the majority opinion here, and it is a convoluted, ambiguous opinion. It is messy in many respects. But to the extent that anybody professes to know what it means, John Roberts is going to be that person. And I have contended all week long that the Trump lawyers sort of treated the presidential immunity decision like a great big piece of elastic or chewing gum. And at some point, that bubble burst because they tried to stretch it beyond its 4 corners, right? They tried to say, for example, that immunity should apply to a president-elect because there was something so special about this transition period that it was just like being an actual president, that you were imbued with so many important things to do vis-a-vis the transition that it was just as if Article 2 of the Constitution should apply to you during that period. The DA's office wholly rejected it, said, no, we have only one president at a time. And I think that argument was probably offensive to Justice Roberts. Again, he wordsmithed, or we imagine that he wordsmithed over that opinion and labored over it intensively in order to keep together that 6-person coalition that formed the majority for most of that opinion. That means when somebody comes to him and says, this is what it means, and he says, that's not what I said, that would be particularly offensive to the author of that opinion. And I think in some respects, that's what happened here. That elastic band turned into like the proverbial slingshot right back at Donald Trump, forcing him to at least appear virtually tomorrow at his sentencing, Joy.
There was a bit of an amen in your nod.
Amen. And I agree with Lisa. Shout out to Chief Justice Roberts and to Justice Barrett for doing the right thing. But again, when we look at the people who are most responsible in the court for protecting our democracy to the extent that they can, it's Justice Sotomayor, Justice Jackson, and Justice Kagan. So they are the people who deserve most of our respect here.
And Andrew, you know, the challenge that I have is that John Roberts, if you want to talk about something elastic, it is his interpretations of the Constitution. Section 3 of Article 14, it means something sometimes, but not when it's Trump. You know, presidents have absolute immunity, but I'm not saying they're above the law. It just seems that he sort of does whatever feels politically expedient. So I'm very reluctant to give him tons of credit here. The outcome, I think, though, is just. But while we're on that train, and we seem to be having a train moving at least slightly toward justice, there is another issue. Judge Cannon took a little piece of Clarence Thomas's, one of his concurrences, and stretched that elastic to say that Jack Smith was wrongfully and unconstitutionally appointed. And she used that to throw out the documents case in which Donald Trump took home classified documents and put them in his bathroom. Now we have a question of whether or not Jack Smith's work product, which belongs to the American people, will be seen by the American people. Where do you suppose that is going in terms of whether the Justice Department, whether Jack Smith, whether Merrick Garland, I should say, will fully release both of these 2 reports that were produced for the American people on the insurrection and on the document theft?
So what I think it's important for people to know is right now Judge Cannon has said you cannot release either Volume 1 having to do with the January 6th case or Volume 2 having to do with the Mar-a-Lago classified documents part. There's so much to say about her decision and why it's wrong. I mean, starting with the fact that she had no jurisdiction, that she didn't wait for the government to even be heard, and that she didn't even have the January 6th case before her, and yet she stayed the release of that part. This is now in the 11th Circuit. The 11th Circuit, the Court of Appeals that oversees her, they have reversed her twice already, and I am confident that they will reverse her with respect to the January 6th part of her decision. And so we will see the January 6th report, in my view, and I think we will see that obviously before January 20th. With respect to the Mar-a-Lago piece, I think that the real issue here is that Merrick Garland has said that he does not intend to publicly release that because there are, in his view, 2 defendants remaining, the 2 co-defendants remaining in that case. Remember, the case has been dismissed by the government without prejudice as to Donald Trump. but they haven't dismissed the case as to the other defendants. I think Merrick Garland has made the wrong call there, because there's no way in God's green earth, and that's a polite way of putting it, that those two co-defendants are ever going to be tried under a Trump administration. They're either going to get pardoned or the case will simply be dismissed by the Department of Justice. So it doesn't make a lot of sense to me that Merrick Garland does not want to release the volume having to do with Mar-a-Lago. He does say that he wants to give that report, however, to certain people, the ranking members in Congress, so that they have an opportunity to see it. So it won't be completely buried. The Congress will have that opportunity. But I think, Joy, to your point, I think with respect to the Mar-a-Lago piece, that is something that we're entitled to see. And there also is likely to be information in there, not only about Donald Trump and, according to Jack Smith, why he took the documents and what he intended to do with them. But remember, Kash Patel is all over that case. And Kash Patel has said that he saw Donald Trump declassify the documents. And we know that Jack Smith thinks that's not true. So it would be useful to have all of the evidence about that before a Kash Patel confirmation hearing. So I think there's more to be continued there. It's a complicated story, but I think the main holdup there is not so much Judge Cannon or the 11th Circuit. It is really Merrick Garland, and whether he is going to continue to adhere to the position that he does not want to release publicly the Mar-a-Lago portion of the report.
Merrick Garland making the wrong call? Shudder to think. Shocker of all shockers. Paul Butler, Lisa Rubin, Andrew Weissman, our dream team, thank you for being here and available tonight for this breaking news. Be sure to join MSNBC tomorrow morning for special coverage of the Trump sentencing beginning on Morning Joe. The sentencing is scheduled to begin at 9:30 a.m. Eastern.